Hi, today I am going to share with you about the remedy you have when you enter an agreement of sale with general power of attorney. This is the document and the nomenclature that is used for a transaction between the buyer and the purchaser of an immovable property like plot, flat, house, lands, etc., wherein you pay the entire sale consideration to the vendor, that is the seller, and take possession of the property, but you keep the registration pending, the final registration pending. There could be hundreds of reasons for keeping the final registration pending. I am not going to go into that. I am going to share with you the legality of that particular document. So the legality or the nomenclature of that particular document, which is in vogue in Telangana and Andhra Pradesh, which are my states. I don't know about other states, you have to inquire with the local law there. The document is called Agreement of Sale cum General Power of Attorney. You know what is Agreement of Sale, you know what is GPA. When both are clubbed and registered, it is called Agreement of Sale with Possession and General Power of Attorney and registered. So it is called Registered Agreement of Sale with Possession cum General Power of Attorney. This is the exact term that is used in the document. The main feature of this document is you pay the entire sale consideration. That is the vendee, that is a buyer, pays the entire sale consideration of the transaction, takes possession of the property, physical possession, symbolic possession, and then takes a GPA from the vendor also, from the seller also. So now the seller has two roles, as a seller or the vendor and as a principal. Here, what is left in the entire transaction? I'll come to that. So the vendor has two roles, vendor as a seller, vendor as a principal. Now the buyer has two roles here, the role as a vendee or the buyer and as an agent. Now please note that there will be a very important clause called time is not the essence of this contract. So now what is left over in this transaction? The entire consideration is paid, the possession is taken, you are in that property physically, symbolically. What is left is the vendor needs to come to the sub-registrar office to execute the final sale deed or the conveyance deed, gift deed, etc., anything. So agreement of sale is done, GPA is given, consideration is paid, possession is taken, the document is registered. Now the only act that is left pending from the side of the vendor or the principal is coming to the registration office and executing the final sale deed. In those circumstances, if the vendor could not come or the buyer decides to get it registered to some third party or hold it in the intermediate time safely, securely, then the document that is executed is called Agreement of Sale cum General Power of Attorney. So the two roles that are played by in this entire transaction is the sale, the role of a sale process and the role of an agency principal process. Now what happens if one of the person dies? If the principal dies, what happens? If the agent dies, what happens? What happens to this transaction? The remedy is, if the principal dies, nothing will happen because the entire transaction is complete by paying the total sale consideration and taking possession of the property. And the right of the agent, the interest of the agent, the title of the agent is with the buyer. Remember this, who is also the agent of the transaction. So if the principal dies in accordance with the Contract Act and the latest Supreme Court judgment reiterating this principle, reiterating this concept, confirming this concept, that if the principal dies when agent is having an interest in the property, right in the property, nothing happens. The transaction goes ahead and continues. And if an agent dies, principal is alive, agent dies, then also principal doesn't have any role. The legal heirs of an agent, because here he is not only just an agent, he is a buyer also, and the legal heirs of the buyer, the legal heirs of the agent will continue the transaction. That is by going to the court or obtaining a legal heir certificate from the court. So in the way, the transaction never gets abated, never dies, because the sale consideration was paid and the interest of the agent is subsisting even though the principal dies. So therefore, there is nothing to worry when an agreement of sale with general power of attorney is registered, total consideration paid, possession taken, and principal dies. There is nothing to worry forever. Hope I am clear. Thank you. Thanks for watching. If you have any doubts, kindly comment.